If I apply for my brother and sister, can they stay in the United States while their case is pending? Hi, I'm Jim Hacking, immigration lawyer practicing law throughout the United States at our offices in St. Louis, San Diego, and Washington, D.C. When a U.S. citizen files for their spouse, or files for their mom or dad, or files for their kid, those people are called immediate relatives. That means they can stay in the United States until their case is adjudicated, and they can even get their case decided if they were out of status at the time of filing. That is, if they overstayed a visa. That is not the case for any other category of immigration cases. So, the brothers and sisters of U.S. citizens, they can have an I-130 petition filed on their behalf. So if you're a U.S. citizen and you want to sponsor your brother or sister, you are free to apply. The current wait time on those cases is 15, 16, 17, 20 years, depending on what country you are from. And a lot of people want to know, and I got a question on my YouTube channel today, Jim, can my brother or sister stay here while that I-130 petition is pending? And the answer to that question is no, because they won't have status simply because the I-130 was filed for them. Now, conceivably, if they were here on an F1 student visa and had stayed all these years, or if they had been on a student visa for a while and that was filed after the I-130 was pending and after it had been pending for a while, in theory, it could happen that someone was in the United States in valid non-immigrant visa status, but in the typical situation, what you're talking about and what was being asked in this video comment was, hey, my brother and sister are here on a B1, B2. I want to file an I-130 petition for them. I'm a U.S. citizen. They're only supposed to be here for 6 months. If I file that I-130, can they stay like a spouse could or my mom could while that whole case is pending? And they can't. They have to be in status at the time they file and have to be in status at the time they adjust. So if they came on that visit visa and their 6-month trip expired, they would have to leave the United States ahead of time, and they'd have to stay outside the United States until the I-130 petition was approved. Right now, with that huge backlog, which is caused by the fact that there's all these people in line ahead of you, they're working on cases from 16 years ago, 20 years ago, depending on what country you're from. So it gives you no right to stay in the United States while your case is pending, and that's the fundamental problem with this person's question. The other thing to keep in mind is that, let's say they have a 5-year multiple entry visa, and this is going to take 16 years, 17 years to get it approved. Well, the next time they go for their visa interview, for their non-immigrant visa to come to the United States, they might get denied because they've demonstrated immigrant intent. Once you have filed that I-130 petition for them, you've made it clear that they want to stay in the United States, and then that's a big problem because that is inconsistent with the non-immigrant visa, the B1, B2 that they want to get. Now, in my mind, the delay is so long that just filing that I-130 should not demonstrate immigrant intent so that you don't get a visit visa, but that I'm not in charge of the State Department, and that's not how things work. I think it should be treated more like the diversity visa cases, which is it's such a long shot and it's so far away. You should be able to file an I-130 petition for your brother or sister, and they should be able to get visas to come back and visit during that long decades of delay. So I hope this makes sense, but long and the short of it is, if you're a U.S. citizen and you file for your brother and sister while they're on a visit visa, they have to leave on time. And if they want to come back, they might need to get another non-immigrant visa. And when the time comes, when their I-130 is approved and it's all been processed, we're talking 15 to 20 years, then they'll be able to come. Hope this makes sense. Hope you understand. Hope I explained it well. If you're looking for help filing an I-130 petition for your brother or sister, or if you filed one long ago and now it's time for processing, we would love to help you with that. Those are the kinds of cases we handle every single day. Call us, 314-961-8200. Email us, info@hackingimmigrationlaw.com. If you're just looking for some free resources, we got plenty of those. We have hundreds of YouTube videos. We have our immigration hacking TikTok account. We also have our immigration answer show where I answer immigrants' questions every single day for an hour. I do that 3 or 4 times a week, and we would love to see you there or in our Facebook group, Immigrant Home. Thanks so much, and we'll see you next time.